Good evening, students. Today's session on Indian polity, we are going to discuss a very important topic. According to me, this is the most important topic in Indian polity, and that is basically about fundamental rights, the limitations and scope of fundamental rights. One of the most asked questions, one of the most asked topics in your exam, any given point of time, this is what is asked the most. So, what are we going to study about fundamental rights? I'll explain today in our session. I'm just trying to check if the live. Okay. Fundamental rights. Basically, in this topic, I'm going to tell you about the applicability of fundamental rights. That's the most important point. Now, what do I mean by applicability? Where, to what extent can we stretch fundamental rights, and to what extent are fundamental rights limited? But before that, I'll briefly tell you what is a fundamental right. Why are fundamental rights called fundamental? But because that also defines the scope of fundamental rights. So, we're going to discuss all that. Okay, let's begin. Now, what is the scope of fundamental rights? You can always ask me questions. Let's understand the meaning of fundamental rights. Can rights be defined? Yes, the answer is it can be defined. The meaning of right is basically an entitlement or obligation, sorry, entitlement or claim. Whenever I say I have a right on this, I am taking ownership. I am claiming. Now, what do I mean by entitlement or claim? It basically means that I will draw some benefit out of it. That is the meaning of a right. For example, if I tell you I have a right on this pen, what do I mean by this? It means that I own this pen. I, I can do whatever I want with this pen. So, entitlement or claim, where you draw some benefit, that is called as a right. Then, why do we call fundamental rights rights? Fundamental rights. So, meaning, why do we use this word fundamental before rights? What are they fundamental for? What do you mean by fundamental? Fundamental means basic. So, my question is, what are they basic for? Okay. Now, basic for what? The answer is simple. One, they serve the basic purpose of the Constitution. What is the basic purpose of the Constitution? The basic purpose of the Constitution is to limit the power of government. Whenever you say constitutional government, it is limited government. Government cannot do whatever it wants because its power is limited by the Constitution. And the best way to impose this limit is by giving fundamental rights. That is the reason, by giving rights to citizens. That is the reason why we say fundamental rights are negative obligations on the state. What do you mean by this? It means that negative obligations on the state. It simply means that they tell state what it should not do, not what it should do, but what it should not do. Basically, it tells the state what it should not do. It says, Constitution says, you state don't violate citizen rights. This is your limit. For example, Article 16 says no favoritism or no discrimination on grounds of race, religion, caste, sex, place of birth, place of residence, in matters of public employment. So, what do you mean by this? You cannot favor anybody. You're telling the state, recruit, but no favoritism. So, when you're saying don't do that, you are drawing a limit on the power of the state. They are the most important tool to achieve the basic purpose of the Constitution. That is the reason they are basic. Okay. The second reason why they are basic is because they play a key role in achieving the aims and aspirations that are given in our preamble. Most important, like we say, we are democratic. Right to freedom of speech and expression is a the most essential condition of democracy, because voting is also a form of expression. Okay, so democracy, you can relate to it. Then we talk about secularism. Without the right to freedom of religion, there is no secularism. We talk about justice. Political justice is ensured through fundamental rights. We talk about equality. There are rights related to equality. There are rights related to liberty. So, without these fundamental rights, achieving what is envisaged in the preamble is not possible. The third important reason why they are very, very basic, fundamental or basic is, do you know, we have something called as Universal Declaration of Human Rights, in which you have 30 human rights listed, out of which the rights that are listed under 2 to 22, they come under the ambit of fundamental rights, meaning fundamental rights are related. See, these came up before our constitution, so I'll not say these influenced them. In fact, I'll say that fundamental rights 2 to 22 of Universal Declaration of Human Rights are found in our fundamental rights. So they cover all basic human rights. The most basic of all human rights, all rights, is right to life. So they cover all basic human rights. Okay, so these are the reasons why we say fundamental rights are basic rights. Okay, they are very, very important. They see, in fact, in my classes, I take fundamental rights only for about 15 to 17 hours. You know why? Because every right, every clause, every subclause, every amendment, every important interpretation of Supreme Court, every doctrine, everything is important. Okay. In fact, I'm recording a polity course for UPSC as well as state PSCs, in which only fundamental rights is taking me around 13 hours till now. I have recorded. I still have a few classes to record. So, fundamental rights is something that you have to be thorough, out and out thorough, because they'll not just give you base for your prelims, but also for your mains. Okay. If you have any comments, please post them. If you have any questions, please ask me. Now let's understand what is the meaning of scope and limitation. What do we mean by these two terms? Scope is basically where is it applicable? Where all can you use it? Okay. Where all it cannot be applied, where all it will not have any impact. Okay. Applied, where all it will not have an impact, that is called as limitation. Now, what is the scope of fundamental rights? I have already explained the scope of fundamental rights. Part of it in this, the scope of fundamental rights, it covers basic human rights. It is very, very important because it ensures that the basic purpose of the constitution is fulfilled. It limits the power of government. We move further and we understand what is the scope of fundamental rights. The first thing that you should know in scope is fundamental rights are applicable to citizens. In some cases they are applicable to citizens and aliens. Now, the question is, how do I know whether they are applicable to citizens or aliens? Wherever you have the word citizens mentioned in the fundamental right, it is applicable to citizens. Wherever you find the word persons, no person shall be denied the right to life and liberty. Wherever you have the word persons, it is applicable to citizens as well as aliens. So the scope of fundamental rights is not just limited to citizens. In certain cases, they are also applicable to aliens. This is about the first point. The second point is, please remember, fundamental rights are justiciable, meaning you have a legal entitlement to fundamental rights. You can go to the court if your fundamental right is violated, is denied. How is this ensured? There are three very important articles: 12, 13 and 32. I'll tell you the link. Simple. 12 will tell you who can violate fundamental rights. What do I mean by this? It means that it will tell you against whom you can file a case of violation of fundamental rights. 13 will tell you what can violate fundamental rights. What do you mean by this? What action will you take that can violate your fundamental rights? Meaning, when you go to the court will ask you, what is your case? Okay, then you will say that this happened to me. Okay, so in this happened to me, you have to point out how your fundamental right has been violated. Then the court will ask you, but who did it? Then you will say that XYZ did it. That XYZ should come under the ambit of 12. That action should come under the ambit of 13. Then 32 will tell you what is the legal recourse applicable available to you for restoring fundamental rights or to ensure that your fundamental rights are protected. It tells you that you can approach a Supreme Court directly. Very, very important. See, why this is important is India has integrated judiciary. There is no other case except for a few, like dispute, center state disputes or election disputes of president and vice president. You cannot go to the Supreme Court directly. It is the apex court. You're in an integrated judicial setup. But when fundamental rights are violated, you can directly go to the Supreme Court. And mind you, Supreme Court is constitutionally bound to accept the case of violation of fundamental rights. So basically, the highest court in this country is supposed to be the custodian of fundamental rights. Don't you think this is very, very important? You're making the highest court in India custodian of fundamental rights. Just fundamental rights are justiciable in nature. This is the second point in scope. The third point in scope in its applicability is, please remember, fundamental rights are so powerful that any law violating one or more fundamental rights, more fundamental rights can be declared invalid. Okay, this is very, very important. Any law. Now, fundamental rights, ordinary law. If ordinary law is violating fundamental rights, it can be declared invalid. In fact, if there is any custom or tradition that is violating fundamental rights, it can be declared invalid, or it can be banned. For example, we had this triple talaq case, Shaira Banu case. In that, very clearly, Supreme Court had said that triple talaq, though it is customary, it is not written anywhere, it is not legal, it does not have a legal backing. But triple talaq, instant talaq, is a violation of fundamental rights of women. That is the reason why Supreme Court declared it invalid. Likewise, we had LGBT, Section 377. They were discriminated. So the legal section actually led to social outcasting of LGBTQ. Supreme Court has invalidated. Take the case of Shabarimala, women entering temple. So there are so many instances where Supreme Court has said that a tradition or custom violating fundamental right can also be declared, can also be banned or prohibited. Okay, this is very, very important because this is about the conflict between right and custom. Which one should be given more importance? Should I give more importance to a right or a custom? Now, I'll specifically talk about the case of women entering Shabarimala temple. I know it is a little controversial, but I'll give you a very clearer picture as to how law works. See, I myself in that age group, if you ask me, would you prefer going to Shabarimala temple? My answer is no. That is my personal choice. I would never step. I would never override that rule. But that's my personal choice. That is my understanding of my religion and its customs. Okay, now what the court said is, when we talk about this custom, is it an essential practice? Is it that in Hinduism women are not allowed to enter temple? Nothing like that. Women go to many other temples. Even Ayyappa Swami temple, except Shabarimala, women go to all other Ayyappa Swami temples. So when it is not a essential practice, what do you mean by an essential practice? That which defines you as a member of that religion. For example, in Islam, the most essential practice is reciting the namaz. Now, are you going to recite the namaz in a masjid, under a tree, or in your house? It is up to you. But reciting namaz is considered to be one of the most essential practices of Islam. Meaning, if you are a Muslim, you are expected to recite namaz. So, like this, every religion will have certain essential practices. Only if it is an essential practice, then we give it more importance than the right. But if the right is if it is not an essential practice, then undoubtedly the rights are more important than the custom. For example, a custom like sati is a violation of right to life. So sati happens, it is undoubtedly a violation of right to life. So this is how we look at the scope of fundamental rights. Now, moving forward, the next points that we have to remember is, as I said, fundamental rights are negative obligations on the state. They tell the state what it should not do on the state. They tell the state what it should not do. Don't do this. Cannot discriminate. Cannot deny. Cannot deprive. So we are telling the state, don't do this. Okay, so there are negative obligations in this to the state. They tell the state what it should not do. Five, please remember, fundamental rights are subjected to judicial interpretations, and very wide judicial interpretations. Very, very wide. Do you know which article has been widely interpreted? The widest interpreted article is 21. Right to life and personal liberty includes 26 other rights. There are nearly 26 other rights that come under right to life and personal liberty. Hmm. Very, very, very important. There's a lot of scope for judiciary. For example, in Justice Puttaswamy case, right to privacy was declared as a part of right to life and personal liberty. In Mohini Jain case, right to education was declared as a part of right to life. Hmm. Like this, there is a scope, there is a very wide scope of judicial interpretations. Hmm. Sorry, constitution is written. Hmm. Constitution of India has been written in such a way that it allows a lot of interpretations. Do you know? Right to vote, right to remain silent, right to dissent, all these are considered as part of right to freedom of speech and expression. Right to press is a part of right to freedom of speech and expression. So this is about judicial interpretations. And please remember, fundamental rights are ever evolving. Why am I saying they are ever evolving? Because of judicial interpretations, because of amendments. More amendments, more rights added. For example, right to education was added, right to form cooperatives was added. And judicial interpretations are widening the scope of fundamental rights. In fact, the judicial interpretation of fundamental rights and its wider scope can be a topic in itself. There have been so many judicial interpretations, so many cases, so many judgments that have been given. There are so many doctrines. We have doctrine of waiver, doctrine of essentiality. Then we have doctrine of severability, doctrine of reasonable classification. All these are ensure that the fundamental rights evolve. They are evolving. They are still evolving. There is nothing like हाँ यहाँ पे it is over for fundamental rights. Now moving forward, what are the limitations on fundamental rights? The first and the most important limitation is they are suspendable in nature, especially when national emergency is imposed under certain conditions. Fundamental rights, national emergency imposed compulsory only during national emergency, they will be suspended. Suspension of 19. Once you impose national emergency on grounds of war or external aggression, automatically you don't need a separate order. 19 stands suspended. 19 is suspended, automatic suspension. Okay, when national emergency is imposed, 20 and 21 cannot be suspended. No matter what, you cannot suspend them. What about the remaining rights? Remaining rights may be suspended. President has to issue a separate order, presidential order, on the basis of which remaining rights may be suspended. Okay, so the first limitation is suspension. Okay, the second limitation is in the form of Articles 33 and 34. Now, what does 33 say and what does 34 say? 33 basically says that Parliament can by law restrict fundamental rights for uniform services, for those services which are into providing security to the country. So, to restrict the uniform services, Parliament by law can restrict fundamental rights for uniform services. First major point. The second major point that you should remember is 34 says whenever there is martial law imposed, Parliament can by law restrict the fundamental rights. And this law is called Armed Forces Special Powers Act. Very, very controversial, important. So these are restrictions on fundamental rights under Articles 33 and 34. The other restriction is there are reasonable restrictions on fundamental rights. Please remember, fundamental rights as given under the Constitution are not absolute. They have reasonable restrictions. Why? Because you have to balance everybody's rights. Okay, so they are not absolute in nature. For example, you cannot use your right to affect the sovereignty, unity, and integrity of India. You cannot use your rights to affect to affect the public order. Your rights should not violate decency and morality. Your rights should not affect health, others' health. So, like this, there are restrictions imposed. Why should you impose restrictions? It is as simple as X has his own rights, Y has his own rights. You enjoy your rights in your sphere, you enjoy your rights in your sphere. You should not do this in order to prevent this. What will happen if X spreads his wings? He will automatically violate Y's rights. For example, best example is I have the freedom of speech. Does it mean that I can abuse a person in public, assassinate a person's character in public? The answer is no. I should not do it because when I do it, I violate the dignity of the other person. Therefore, defamation is a restriction on right to freedom of speech and expression. So, like this, reasonable restrictions have been imposed by the Constitution on fundamental rights to ensure that there is a balance. Everybody gets to enjoy their right. We don't violate each other's rights. And then there are also restrictions in the form of reasonable classification. See, whenever there is any discrimination made by the state, meaning any positive discrimination made by the state, it should be on the basis of reasonable classification, doctrine of reasonable classification as applicable under Article 14. So, this is another limitation. And finally, another very important limitation is directive principles of state policy. Fundamental rights and directive principles of state policy correlate with each other, they cannot violate each other. But, if at all there is any situation where there is a violation, then the court will take a look at which one is more important. In fact, 39B and C are so important that you cannot violate them for even 19 and 21. Even if it is about fundamental rights, the Constitution itself places this. Even if it is about fundamental rights and DPSP are non-justiciable. But in case of 39 BNC, you cannot declare them any action taken by the government to implement 39 BNC cannot be declared invalid for violation of 19 and 21. So these are the scope of fundamental rights. Scope and limitations of fundamental rights. Hope the session was clear to you. If you have any doubts, please post them in the comment box. I'll meet you tomorrow with another topic. Thank you so much. Bye bye. Good night.